Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Before the courtroom battles, legal arguments, and final judgments, there exists a powerful yet often overlooked stage in civil litigation, court mediation. Have you ever wondered if you could resolve your legal dispute without going through the long, costly, and emotionally exhausting trial process? Today, we uncover the 19th stage of a civil case, mediation, an efficient, confidential, and strategic process that can settle your case even before trial begins. 1. What is mediation? Mediation is a voluntary and confidential process where parties involved in a civil dispute come together to explore a mutually acceptable resolution with the help of a neutral third-party mediator. Unlike a judge, the mediator does not impose a decision but facilitates constructive dialogue. It's less about law and more about resolution. In Indian civil litigation, court-referred mediation is governed by Section 89 of the Code of Civil Procedure, 1908. Rules framed by high courts for mediation centers. Mediation Act, 2023, latest legislative framework. 2. Why is mediation stage 19 in civil proceedings? In a typical civil case, the process involves 20-plus stages: filing, replies, discovery, framing of issues, and finally trial. But after pleadings are complete and before the trial formally begins, the court often recommends mediation. This is stage 19 in many civil jurisdictions. This is where disputes are referred to the court mediation center, and parties are given a chance to settle, if possible. The goal? Save time, court resources, and emotional energy. 3. The mediator's role and mediation structure. Mediator's role: acts as a neutral facilitator, ensures both parties are heard, helps generate options for settlement. Mediators are usually senior advocates or retired judges trained in negotiation and communication. Structure of mediation. 1. Introductory session, mediator explains the process. 2. Joint meeting, both parties present their sides. 3. Caucus, private session, mediator meets each party privately. 4. Negotiation and closure, if a solution is found, it's put in writing. Confidentiality. What's said in mediation stays in mediation. Cannot be used as evidence in court if mediation fails. Ensured by mediation rules and ethics guidelines. 4. Benefits of mediation. Why should you or your client choose mediation? Time efficient, most mediations conclude within a few sittings. Cost effective, no lengthy litigation costs. Preserves relationships, especially important in family or business disputes. Flexible solutions, parties can agree on outcomes courts can't grant, like apologies, payment plans, creative business arrangements. Real-world example. In a property dispute between two brothers, mediation led to a mutual family settlement, something a court order could never achieve in that form. 5. When mediation may not work. However, mediation is not a magic wand. It may fail in cases involving serious power imbalance, bad faith or non-cooperative parties, complex legal issues needing judicial determination. If mediation fails, the case returns to court for regular trial proceedings. But failure doesn't mean waste. Parties often come back to mediation later after understanding the cost of litigation. 6. Tips for a successful mediation. To make the most of court mediation. Be prepared, know your facts and what you want. Be flexible, don't enter with rigid demands. Stay realistic, settlement means compromise. Mindset matters, go with an intention to resolve, not to argue. 7. The future of civil dispute resolution. With the new Mediation Act, 2023, and increasing judicial burden, India is moving toward a mediation-first approach. Courts are actively encouraging parties to consider mediation as a first step, and in many cases, compulsory pre-litigation mediation is being introduced. The future is clear. Mediation is no longer a soft option, but a strategic necessity. conclusion, and call to action. If you've ever been part of a court mediation or are planning to, share your thoughts or questions in the comments below. Court mediation is not just a formality, it's an opportunity. Don't overlook it in your legal journey. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.